What is leading question? When it is allowed, what is misleading question? During the direct or redirect examination, the presenting party can only ask neutral questions or questions that do not suggest the desired answer to the witness. Some neutral questions are: where were you on the night of 31 December 2019? How do you know the accused? These questions do not suggest to the witness what answer the presenting party wants to prove their case. During cross-examination or recross-examination, the rules recognize that the witness may be adverse to the opposing party or even behave the hostility. To counteract this, the rules allow the opposing party to ask leading questions. Leading questions are questions that lead to or suggest the desired answer to the witness. Otherwise, put the answer that the opposing party wants it already in the question itself. Usually, leading question will require as a yes or no answer. For instance, to establish the ownership of her bank account, or prosecution may ask to accuse in the estafa case. Following the same consideration, leading question is also allowed when conducting an examination upon an unwilling or hostile witness, or an adverse party of officer director, or managing agent of a public-private corporation, of a partnership or association, which is the adverse party. For efficiency, leading questions are also allowed when establishing preliminary matters, or when the witness who is ignorant, or a child of tender years, or it is feeble mind, or a deaf mute. In this instance, leading question may be asked even during direct or redirect examination, when is circumstantial evidence sufficient to sustain a conviction. Revised Rules on Evidence, Rule 133, Section 4. Circumstantial evidence when sufficient. Circumstantial evidence is sufficient for conviction if A. There is more than one circumstances. B. The facts from which the interference are driven from proven. And C. The combination of all circumstances is such as to produce a conviction beyond reasonable doubt. Inference cannot be based on other inference. Distinguish burden of proof from burden of evidence. Revised Rules of Evidence, Rule 131, Section 1. Burden of proof and burden of evidence. Burden of proof is the duty of a party to present evidence on the facts and issue necessary to establish his or her claim or defense by amount of evidence required by law. Burden of proof never shifts. Burden of evidence is the duty of a party to present evidence sufficient to establish or rebut a fact to establish a prima facie case. During of the evidence may shift from one party to other in the course of the proceedings depending on the exigency of the case. What is standard of proof necessary in civil cases, criminal cases, and administrative cases? Revised Rules on Evidence, Rule 133, Section 1. Preponderance of evidence, how determined? In civil cases, the party having the burden of proof must establish his or her case by a preponderance of evidence. In determining where the preponderance or superior weight of evidence on the issue involved lies, the court may consider all the facts, circumstances of the case, the witness' manner of testifying, their intelligence, their means of opportunity of knowing the facts to which they are testifying, the nature of the facts which they testify, the probability of improbability of their testimony, their interest or what is interest, and also their personal credibility so far as the same may legitimately appear upon the trial. The court may also consider the number of witnesses through the preponderance is not necessary with a greater number. Revised Rules of Evidence, Rule 133, Section 2. Proof beyond reasonable doubt. In criminal case, the accused is entitled in acquittal unless his or her guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt does not mean such a degree proof excluding possibility of error. Produce absolute certainly, moral certainly only is required, or that degree of proof which produces conviction in an unprejudiced mind. Revised Rules on Evidence, Rule 133, Section 6. Substantial evidence. In cases filed before administrative or quasi-judicial bodies, a fact may be deemed established if it is supported by substantial evidence, or that the amount of relevant evidence which is a reasonable mind might accept unacceptable to justify a conclusion. Define what are public documents. Revised Rules on Evidence, Rule 132, Section 19. Classes of documents. For the purpose of their presentation and evidence, documents are either public or private. Public documents are A. The written official acts or records of the sovereign authority, official bodies, and tribunals and public officers, whether the Philippines or of a foreign country. B. Documents acknowledged before a notary public except last wills and testaments. C. Documents that are considered public documents under treaties and convictions which are in force between the Philippines and the country of source. And D. Public records kept in the Philippines or private documents required by law to be entered therein. How do you prove and present in court private documents? Revised Rules on Evidence, Rule 132, Section 20. Proof of private documents. Before any private documents offered as authentic and received in evidence, its due extension and authenticity must be proven by any of the following means. A. By anyone who saw the document executed or written. B. By evidence of genuineness of the signature or handwriting of the maker. Or C. By other evidence showing that the due execution of authenticity. Any other private document need only be identified as what which is claimed to be. Revised Rules on Evidence, Rule 132, Section 21. When evidence is authenticity of private document not necessary. Where a private document is more than 30 years old, it's produced from a custody in which it would naturally be found in if genuine, and it's unblemished by any alterations of circumstances of suspicion. No other evidence of this authenticity need be given. Revised Rules on Evidence, Rule 132, Section 22. How genuineness of handwriting proved. The handwriting of a person may be proved by a witness who believes in the handwriting of a such person because he or she has seen the person write, or has seen writing proportion to be his or her upon which the witness has acted or been charged, and has thus acquired knowledge of the handwriting of such person. Evidence respecting and handwriting may also be given a comparison made by the witness of the court, with writings admitted or threatened as a genuine party against whom and the evidence is offered, or proved to be genuine to the satisfaction of the judge. The original documents rule states that when presenting a document as a evidence, only original is admissible. What are the four exemptions? Who can become a witness? The general rule that only original documents are admissible in evidence admits of exceptions for specific cases when the original documents may not be available for presentation in court. The four specific cases are: 1. The original document is lost or destroyed or cannot be produced in court. 2. The original document is in custody of the adverse party or under the control of a party against whom the evidence is offered, and latter fails to produce if after reasonable notice, or the original cannot be obtained by a local judicial process of procedures. 3. The original document consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result of the whole. 4. The original document is a public record in the custody of a public officer or it's recorded in a public office. When is an extrajudicial confession sufficient to sustain a conviction? Revised Rules on Evidence, Rule 130, Section 34, Confession. The declaration of an accused acknowledging his or her guilt of the offense charge or of any offense necessarily included therein may be given in evidence against him or her.